All right, good evening, everyone. This is Attorney Ismail Shahtakhtinski with you. Thank you, everyone, for joining. I apologize that we had to change the link. I had technical difficulties. That's what happens when you are not a professional blogger. You're still learning. So this is a new link for this live stream. I greatly appreciate anyone who followed, who found this new link. I Something broke with the previous link, and the live stream ended abruptly. If you can please repost this, share for anyone who was interested in joining to join on this link. I appreciate everyone. So again, my name is Ismail Shahtakhtinski, and I'm the principal attorney at IS Law Firm, immigration law firm. We are a boutique immigration law firm in Fairfax, Virginia. We've been in practice for 19 years, practicing handling immigration cases, helping immigrants in their paths to citizenship in the United States. We're a diverse team of individuals from different cultures, and we try to help as much as we can and follow all of the immigration updates. I'm sorry, I'm a little bit nervous again because I'm not a professional blogger, and this happened. I really was nervous that so many individuals have been invited to join our live stream, and unfortunately, that did not take place on the link that we have been promoting to everyone. So if anyone shared and posted, if you don't mind, please post and share with others. But I'm sure after this video, my marketing team is going to share everything, in every portal where we previously shared the link to join our live stream. But let's start. So the topic of, and hopefully, those who are going to miss live stream will be able to review the recording, and we'll get the information. We have very interesting topic, and if need be, we'll be able to come back down the road in the future again, in the nearest future, to this topic to discuss this again. So we are talking about citizenship changes in 2025. There are significant, important changes coming up on October 20th under the new rules of Trump administration. So the point here is we're going to break it down as to what those changes are, what you should know. Rule number one, just let you know straightforward. The first thing that you need to take into account is that if you're eligible for citizenship, file it now. Do not wait until October 20th. There may be more changes down the road. So the first thing you need to know is if you're eligible for citizenship, file it now. File it before October 20th. If the filing process is online, you fill out the application form, you upload the documents, and then you get the receipt right away. As long as you file it before October 20th, all of these changes that we will discuss will not apply to your case because they cannot be retroactively applied. So file it as soon as possible. So the first change is Civics Test. Everybody understands what it is. That's when you become a US citizen, you have to take a test of US history and US civics, and it's done. All of it is done orally at the interview. At the time of the interview, some of it is written English test, and then there is oral English test. So conversational English test. So all of that is changing now. The English test doesn't change, but the civics test, in the past or even currently, when you go to your citizenship interview, you have to study 100 questions for the civics test. It's all about U.S. history and the U.S. government and the democratic system and so on and so forth. So those 100 questions will now be replaced with 128 questions. And currently the officer, the USCIS officer at your naturalization interview, is supposed to ask you 10 questions, of which you need to answer correctly 6. And as long as you answered 6 correctly, then you pass the test. Now, during the citizenship interview, there are other questions, the eligibility questions. They go back and review your entire immigration history. But in terms of the test part, the change is that there will be twice more. So there will be the officer will be asking 20 questions, up to 20 questions, and you have to answer at least 12 correctly. So it basically doubled the number of questions and doubled the number of the questions you need to. The percentage remains the same that you need to answer correctly. But the number of questions, number of possible questions also increased from 100 to 120 up 28. So you have to thoroughly prepare. Don't take it lightly. A lot of you are, highly educated and so on, but still there are some questions which are, not very intuitive. So file for citizenship as soon as possible. The second part of the change is affirmative good moral character requirement. So what it means is that in the past, unless you had, or again currently until October 20th, if you do not have any negative background history, such as criminal charge, criminal case, or something that reflects negatively on your good moral character, then you didn't have to demonstrate any evidence of your good moral character. So it would be presumed that everybody is good. Now, the new rule is that it's not presumed, so you have to affirmatively demonstrate, and it will be very thoroughly reviewed. The officers, the USCIS officers, are instructed to more thoroughly, in more detail, review the applicant's good moral character, or moral character, basically lack of good moral character or good moral character. So you've probably heard of neighborhood investigations and field vetting. That scares a lot of people. What it means is that the USCIS officers are instructed to they are instructed to detect those cases which warrant more investigation, and there will be, as they're promising that there will be more, or as they're scaring, trying to intimidate, is that there will be more neighborhood investigations and field vetting, where immigration officers can be coming to your neighborhood, asking questions about your good moral character, about your behavior, and what others think about you. That sounds unrealistic, but it's possible. I mean, the USCIS does investigations in many other types of cases, but the resources are limited. So I'd say they're not going to be able to do it on every single case, but on case by case, if there is a questionable moral character, they may do so. But I want to demystify it. It's not something that hasn't been done in the past. Not in the context of citizenship, but it's been done in the context of, marriage-based case, or business visas, workplace investigations, where immigration officer would come over to the workplace to audit, to verify that the sponsored employer is actually employed there, and so on and so forth. So the USCIS has traditionally always done investigations. They do it every day. Again, I'm not talking about ICE, Immigration Customs Enforcement part of it, but this is investigations. They would go in a marriage-based case. They would sometimes knock the door early in the morning to verify that the couple reside together. They would do site investigations and so on. That has always existed. Now, in the context of citizenship, what they're saying is that they will increase those types of investigations, or they will actually do those types of investigations, which haven't been done in the past. So in terms of that, not be intimidated. This is not something scary, as long as you're a reasonable person. Your entire neighborhood is not going to badmouth you, and so on. It's just ridiculous that we live in this time when this is happening. But still, it's not something to be too mystified about. The affirmative proof of good moral character, I want to come back to that. So what it means is that at the time of filing your application, after October 20th, or any time, I mean, it doesn't hurt, even do it now, you should provide affidavits from those neighbors, not all of the neighbors, maybe one neighbor, let's say somebody you feel comfortable with asking for an affidavit to say that you're a good person, you're a good candidate to be a US citizen. You may get an affidavit, or it doesn't have to be a notarized affidavit. It can be sworn statement. There is a format for a sworn statement, so it doesn't have to be notarized. So to make it easier for them, you can get a letter, for example, from your other community members, from church, or mosque or synagogue or any other religious organization group that you're attending, that you may have volunteered. It may be just a nonprofit organization you've worked with, you helped in the past. I wouldn't go overboard with it. Maybe, one from each, and total of three, four would be helpful, so that you are affirmatively demonstrating good moral character. One important one could be from your employer. So your employer could write a written statement, a sworn statement confirming your good moral character. Now, I've had questions whether we should provide, DMV records. I wouldn't go that far. Not only that far, but the fact that you haven't had any traffic tickets doesn't really much affirmatively prove anything good moral character. It just proves that you don't have lack of good moral character by driving erratically and getting a bunch of, reckless driving and DUIs and so on. So not committing crimes, I want to say, is not necessarily affirmatively good moral character. It basically says you're basically where you're supposed to be, but it doesn't, move the scale on the positive side. So don't boast about, not committing crimes or not getting traffic tickets. Although it's not getting traffic tickets is something to be boasting about. I agree. Yeah, it's very important to gather those. And if you do those, there is much less chance that there will be any kind of background investigation, or also your case may be processed much faster. Now, if you do have any traffic tickets, you have, speeding, wrong U-turn, whatever that might be, HOV violations, and so on, don't be alarmed. So none of those traffic tickets by themselves would or even two or three of them generally would prevent you from becoming a US citizen. It's just not going to be, demonstrating lack of good moral character. But if you have too many, and there is no specific number, but I'll tell you a case from many years ago, which I have observed. There was an individual who had probably 20 different traffic tickets, 20 or more different traffic tickets, and he missed a lot of court hearings. So he also had orders to show cause. He was found guilty in absentia. Those were, some were reckless driving and so on, but none of them were, even reckless driving in his case, were misdemeanors. But in combination, all of them together, with the fact that he basically hasn't taken seriously, I think he also had one with driving with suspended license. Anyway, bottom line, the USCIS cumulatively decided that, the person lacks good moral character because he's basically been ignoring the laws, even though this is not, criminal laws. These are administrative laws. Traffic citations he had, but he missed court dates, hearings, he missed payments, didn't pay here, there, and then a couple reckless drivings, which were reduced to speeding, but still. So if you have those kind of traffic tickets and so on, don't be alarmed. But if you have too many, if you have those issues, then maybe you have to prove with substantial evidence your rehabilitation. Maybe you took some kind of defensive driving courses, some safety courses. Like when you get traffic tickets in the traffic court, they sometimes, as a condition of lower sentence or lower fine, they send you to those courses. So you can always sign up and take those courses. Again, if you believe that's going to help you, if you have too many cases. Now, if you're not sure whether you should or not, what you should affirmatively do, and generally, in general, always hire an experienced immigration lawyer to navigate through all this to make sure that you're fully prepared for this. If you have a criminal charge or criminal conviction, the difference is criminal charges when you're charged with something, but you may not be convicted because you went to court, the charges were dropped, or you or you proved that you were innocent, um, or the case got dismissed and so on. So that's what's called criminal charge. That means you were charged. So in the citizenship application, there is a question: have you ever been charged, convicted, arrested, and so on for any crimes? So even if you were charged but the case got dismissed, you still have to indicate that. And even being charged, even though you were not convicted, still affects your good moral character, because we're not in criminal court here. You're becoming a US citizen. So if you've been charged with domestic violence, larceny, theft, and so on in the past, and bunch of traffic tickets, and then all of them were dismissed, you somehow navigated, hired, lawyers, and got all those cases dismissed, reduced, and so on. That doesn't mean it's not going to have your effect on your good moral character. It very well maybe. So therefore be very I don't know why it started showing the video. This YouTube is just it's crazy. So I apologize everyone again for all of this. So with the good moral character, with all those charges, it's still going to affect. Now if you're convicted, obviously that's going to have an effect, but again, imagine it as a scale. So if you have criminal conviction charges, traffic tickets, and so on, then it moves, the scale goes to minus, but then you have to demonstrate all the affirmative good moral character, it goes to plus. But after October 20th, you want to start with basically what the USCIS says, by showing all these positives so they don't have to look and see what negatives you might have. Now, they do look and see. That sounded a little strange. I said they don't have to, but they do. So once you file for citizenship, the USCIS goes back and reviews all they conduct a thorough background check. They review your entire immigration history. They verify your previous applications, because normally, technically, that's a last chance for the USCIS, for the US government, to review all your all your prior history, all your prior immigration history, to make sure that everything is consistent. Or it means in many cases, for example, somebody who filed for asylum, got their asylum granted, 7 years, 8 years ago, and then they filed for a green card. That's another form of application. They filled out all the forms and documents and provided supporting information. Then, 5 years later, minus 1 year in case of asylum, 4 years later, they filed for citizenship, and they filled out all these forms and so on. Now, what the USCIS is going to do, they're going to go back and review all your previous forms, all your previous information. And if they identify any inconsistency, they will make a big deal of it. Either you're misrepresenting now or you misrepresented then. And in the worst case scenario, they can place you in removal proceedings, claim that you misrepresented your asylum claim, because back then you said you were arrested, but now you're saying you've never been arrested. So this is a mismatch. So that can cause serious issues. So it's very important to review all of those prior history, prior records, and so on. But if you do have those criminal charges and criminal convictions, so you have to get certified records. So if it's a criminal charge, if it's a misdemeanor, if it's something for which you have been arrested, it could be even reckless driving. You could be arrested for reckless driving, even though they may reduce the charge from misdemeanor to just a traffic citation. You still need to get certified court disposition. Certified court disposition means you have to go to the court, or you can contact the court or hire someone to go to the court where this case was held, and ask the clerk to give you certified court disposition. That's the name of it. So what it means is they'll print out the disposition record showing what happened in your case, and the clerk will stamp or sign that this is a certified record. So you do have to provide those for all criminal cases, where you've been charged or convicted, even if your case was dismissed and expunged. So that's one of the traps many people fall into, is that if their criminal case has been expunged, they believe that they don't have to disclose that to the US federal government. That's very naive. It's naive because federal government, it's expunged from the public view, but it's not expunged from the view even of the state government where this case was. and obviously you have to disclose it in the case when you apply for citizenship. So providing evidence of your good moral character will help preemptively to resolve any kind of issues you may have, or any kind of negative opinion that the officer may have about your good moral character, based on the traffic citations and minor criminal charges and convictions. Now, the difference between minor criminal charge or conviction and the significant one is not something I can explain it here, because that's just an entire science, and there's still ongoing litigation. It requires very thorough, detailed analysis. The bottom line is, if you had too many traffic tickets, if you had criminal conviction, if you had charges in the past, even though they've been dismissed, before filing for citizenship, at the very least, you need to consult with thoroughly with an experienced immigration lawyer to identify how will that play a role and what you should do preemptively at the time of filing. Now, there are some significant criminal charges and convictions, well, not charged by itself, but the convictions, which would prevent you from citizenship altogether. And there are rules as to whether it's within the past 5 years, or whether it's even beyond 5 years, then you may have a permanent bar to citizenship. So there are just so many different factors, so many things that figurate here, and that's why it's difficult. So so under the new rule, as I said, August 2025 memo, which changes the rules. So starting October 20th, the applicants must affirmatively demonstrate good moral character. Not enough just to have no record, must show positive conduct. Next, expanded background and data checks. So currently, USCIS, as I said, they do the background checks, they do data checks. What they're saying is that it will be expanded. I don't see how. I mean, it's very thorough anyway. So currently, the USCIS, when you file for citizenship, you know how you have biometrics appointment when you have to take the fingerprints. They take your fingerprints and so on. So those things are done for the background check. So what they do is they do background check with the DHS, Department of Homeland Security. They do FBI background check, and they check with the state databases. So you understand, again, this is a federal government, so they have access to all this. So they verify all of that information. What they're saying is now they're going to do also background check and verify with IRS. Traditionally, USCIS hasn't been, although they do have access, in some circumstances they can, but they haven't been, accessing IRS records. So anecdotally, people would say, well, if I got a 1099, will the USCIS know this, and so on. At the time when I always tell people to disclose it, because technically they can. Of course, you have to disclose it, but if you don't disclose it, it can also be revealed, because the USCIS can technically access. Now, what they're saying is that they're going to have, more. They'll share data with IRS more often, along with DHS, FBI, Department of State. So they will do that. They will check the employment information. They'll check taxes and benefits usage. So why is this important? Is because when you file for citizenship on your Form N-400, it asks for your residency history, the address history, the places where you lived, and your employment history, the places where you worked. And if there is a mismatch, that could be a red flag to see and dig into, see why you didn't disclose this now, but there was information about your prior employment there. Or they can look and see that some company issued a 1099 or W-2 to you in the past, but you didn't disclose them as employer. Why is that? So that's another thing that's coming up based on the information that they provided after October 20th. The other intrusive part is checking social media. So there is a potential for review of social media accounts, online presence. Now, all of this is what they're saying they will do. And I don't blame necessarily. I mean, if somebody's becoming a US citizen, at the same time, even when I hire an employee, I'm not, it's probably less valuable than for that employee to become our firm's employee than somebody becoming a U.S. citizen, right? Well, I mean, it depends how you look at it. I'd argue that otherwise. But anyway, what I'm trying to say is that when I had an employee, I look at their information. We do, as a law firm, our HR and myself, we do background check to the extent that we can. We look at social media presence and so on. So when somebody is becoming a U.S. citizen, it's actually strange to me that they haven't been looking at social media presence much, but it seems like they're suggesting that they'll be more thorough. You may have to, I don't know, disclose more, but I don't think that would be constitutionally valid to require you to give them access or passcode to your social media accounts. But whatever is public, what they're saying is that they will review that thoroughly. So next, they will basically look into your entire background. Again, as I said, public information, public background again about you, anywhere they can. But again, how much resources they have to do that. So those are the immediate changes on October 20th. And what you need to do, the timing is October 20th. So if you know someone or if you are eligible for citizenship, do not delay, file it before October 20th, so that that these rules, these complications do not apply to your case. Now, there are broader discussions about the changes about citizenship or things that relate to citizenship in the United States. So one of the most discussed topics has been after Trump's second administration, is birthright citizenship. So birthright citizenship is citizenship by birth. If somebody was born in the United States, it's written in the U.S. Constitution, they become U.S. citizens. There are exceptions. If you are here on diplomatic visa for diplomatic official purpose, then you're technically not on the U.S. soil. You have the immunities and so on. So the bottom line is that constitutional part of birthright citizenship doesn't apply. But that's an exception. Now, generally under the Constitution, if you're born in the U.S., you become a U.S. citizen. So a lot of you have heard all these litigation discussions and unfortunately misleading headlines in the news that Supreme Court granted permission to the Trump administration to change or to eliminate birthright citizenship, or Trump won in litigation about birth. Well, it is related. What he won in court is what administration succeeded doing is related to birthright citizenship. Well, actually, I would say it's not even related. It was just under that name of the case. And I'll explain to you what happened so that people do not misunderstand. So as of now, anyone born here in the United States are still citizens of the United States. Okay. Now, what Trump did, he issued an executive order saying that no, that's not the case. You have to prove this and that. Now, that's obviously and clearly unconstitutional. And so far, any court in the United States that have looked into the constitutionality of Trump's executive order denying birthright citizenship or conditioning it upon some terms has found that it was unconstitutional. No question about it. Not a single court ever decided that it was constitutional for Trump to eliminate birthright citizenship. Not a single court even hinted that it's even possible for them to do so. Now, he issued an executive order, clearly unconstitutional executive order. He just issued it and said, no, that's it. There will be no birthright citizenship. As soon as that happened, basically under the executive power, basically the citizenship, the passport is issued by the State Department. So the State Department may not issue passport to the child that is born because they don't consider that child as a U.S. citizen yet. Now, what they did is that those children who were affected at that time filed lawsuit against Trump administration saying that this is unconstitutional. The federal court found immediately in those first cases that started in those, and there are ongoing cases as well, they found that it was unconstitutional and ordered that not only that child who's the plaintiff in the case be granted U.S. citizenship by the virtue of birth, but everyone else in the country should be granted citizenship by birth. So basically, uh, invalidating the executive order altogether. The problem with that was that those judges, those district court judges, they are they have jurisdiction over their own district, certain districts. So, can they eliminate the entire executive? Can a U.S. federal district court judge eliminate the entire executive or invalidate the executive order, or should it affect only that specific plaintiff and others in the same region? So that would be the precedent for others. So basically, invalidating it as to this jurisdiction over which this judge, well, this area over which the judge has the jurisdiction. And that was the question addressed to the Supreme Court, that reached to the Supreme Court, where the Supreme Court decided that they didn't decide on whether Trump's executive order was valid or not, because that was not the question presented to them. The question was presented to them in blocking Trump's executive order. Can the district court judge block it nationwide or just in the area where they have jurisdiction? And the Supreme Court decided no, that would be dangerous to give the district court, federal district court judge, the power to basically block the president's executive order. And then they would have to appeal, and then there would be stay, injunction, and so on. So, and then lift of injunction, stay of injunction, so which happens a lot with immigration laws under the Trump administration. So the Supreme Court decided that no, the district court judge's jurisdiction is limited to their jurisdiction in this specific scenario, and they cannot basically issue an injunction all over the nationwide saying no, everybody becomes citizen, or that one way or another. But the Supreme Court intentionally never addressed the question because it was not, well, maybe not intentionally, it never got to the Supreme Court, the question whether one. Basically, the government Trump administration never appealed any of those decisions to prove that he's eligible. Well, I may be wrong. Don't want to give false information. Maybe they appealed, but it never got to the to the Supreme Court. But the bottom line is no. If child is born in the United States, they're still U.S. citizens. There may be instances in some states where it hasn't been decided yet, and there has not been injunction issued by a federal district judge in that state or in that jurisdiction. In those cases, there may be some challenges in terms of timing. So that's about demystifying about the birthright citizenship. That's soon going to die down, and that will be a moot issue. And I don't see any reasonable attorney working for Trump administration bringing this to the Supreme Court, trying to argue that Trump unilaterally can change U.S. Constitution and eliminate birthright citizenship. I just don't see a possibility of this. I would even argue that such a lawyer should be disbarred and deprived of license. I mean, of course, there can be good faith argument that we should change it, but even we should change it cannot be the Constitution. There are ways to change the Constitution. So that's about birthright citizenship. Next is I'm going to talk about denaturalization surge. So denaturalization means stripping off someone's naturalization. So somebody who may have become a U.S. citizen in the past, now they're U.S. citizens, and they may be, theoretically, there are steps, and practically too, it happens. They may be deprived of their citizenship if they were not born in the U.S. Obviously, there is no way to do so. But if they were born in the U.S., there is no way. But if they were not born, if they naturalized, they've been granted citizenship. So there is a process through which one may be deprived of U.S. citizenship. So the citizenship can be taken back. It's a very burdensome process for the government. It's very difficult. It has very high required level of proof. The government basically has to demonstrate that by clear and convincing evidence that there has been fraud involved. Not just that the government made a mistake. Let's say somebody initially may or may have not been eligible for asylum, or maybe there were questions about the validity of the marriage through which somebody became a permanent resident and then became a citizen. those are the things that the federal judge, is not going to address. Now, the USCIS itself cannot deprive anyone of citizenship, although it grants the naturalization. And then, there's oath of ceremony and so on. Then you become a citizen, naturalized US citizen. The USCIS is in the process of granting it. They're authorized to grant, but they cannot denaturalize. They cannot take it away. The denaturalization has to go through federal court. So it's a case filed in the federal, again, same, federal district court, which has to review the federal judge, not the immigration judge, but the federal judicial system judge has to review it and agree that there is clear and convincing evidence. And then there is still process, there is hearing. It's not just unilateral review, but it requires basically them giving a chance for you to present your side of the story and so on, and to defend against it. So it's a very hard process, but it exists, and it's been exercised under every administration. It's not something that Trump administration suddenly decided to do. Now, they are promising a surge on this, and there has been some increase on attempts, but on the success of denaturalization, I'll be honest with you, I haven't seen statistics. I don't think there are necessarily statistics since the beginning of this administration until now as to successful denaturalization and so on. But there is not, I wouldn't say that there is a significant surge. Maybe I'm naively optimistic, but again, the challenge in all this, well, we need to look at two things. One is, what is the reason Trump administration doing all this by announcing we're going to denaturalize, we're going to do this, we're going to do mass deportations and so on, and somewhat doing it, and do they have resources to do it? So one of the things is the reasons they're issuing these memorandums. They're talking about building, an encroachable wall on the southern border, unpassable wall, or putting, making it impossible for someone to cross the Mexican border, U.S.-Mexican border. They're talking about these mass deportations and so on. The reason they're doing it is to intimidate, to create this chaos, to create this hesitation against U.S. immigration into the United States. They want to limit immigration. I mean, that's the belief of radical right, that immigration hurts the United States. Now, some of the people may have these racist, xenophobic reasons for that. Some may have economic reasons. They truly believe that economically immigrants are taking their jobs and so on. But we're not going to go there. But the bottom line is the declared goal of Trump administration is to limit U.S. immigration, to reduce it. Not just illegal immigration, also legal immigration. Okay, they don't believe in data. They don't believe in science. Again, I'm not going to go into politics. For example, the H-1B visa fee, 100,000. That's ridiculous, because those H-1B workers, they're not really taking jobs from U.S. workers. There is a limitation. They're not talking about this, right? There are 65,000 visas every year, and 20,000 for people with advanced degrees, such as masters and above. And those jobs are there because the Congress has already determined that we need U.S. businesses to be able to hire foreign workers, and they keep saying that those workers are hired on cheap wages and they're exploited and so on. That's not true. There are things that take place, such as employees tied to their employer and so on, and they cannot. In many cases, they have difficulty finding a new job, although they can transition their H-1B, but still. So. But those workers, they don't work on cheap, low salaries. In fact, the employers are required to pay at least median wage, which is determined beforehand, before filing for H-1B, is determined, what's the median wage to pay for this position, and that's what those employers are required. The bottom line is what I'm trying to say. I kind of went off the track, but the Trump administration is trying to intimidate, to limit immigration. So all of these talks about these extreme vetting for citizenship, that we're going to denaturalize, we're going to block birthright citizenship. They know they're going to lose. They know that those executive orders and so on will be blocked. Those new rules will be found, unconstitutional and so on. So they know this, but they still do it because some people will be hurt, some immigrants will be hurt, some people will be, held in detention, and the word of mouth will spread that the United States is not welcoming immigrants anymore, not only just in words but also in action. So they do that, and that's the purpose. The entire purpose, it's declared. It's not a secret. It's not something that I'm coming up with. It's what Trump is boasting about every day. So they're trying to limit immigration into the United States. In fact, well, I'll tell you, the other day, the official page of the Department of Homeland Security Facebook page had a post which I found disgusting. It said America is for Americans only. We are asleep no more. America for Americans. We're asleep no more. Now, may sound, yeah, well, of course, America is for Americans, but what does Americans connote? But anyway, I'm not going to go there. I had a separate post about this, but the official page of the Department of Homeland Security is repeating Nazi slogans, the Germany for Germans, or the current Russian xenophobic slogan of Russia for Russians. So this is what's going on here in America now. Now, the reason why they're doing it is, again, to intimidate, to what they think is their cleaning America of the immigrants. Now, do they have resources to do so? To some degree, yes. But a lot of things that they're saying that they will do, the denaturalization, it's just I don't see the possibility. So they are intimidating by these notices, memos, and so on. But realistically, how much they can do? In every denaturalization case, there has to be a U.S. attorney involved, meaning the attorney who's going to represent the government, the prosecutor. There are resources. There has to be enough judges. They have to have enough, support staff to support all this. Those are not simple cases. They're much harder than any kind of traffic case or simple misdemeanor case to denaturalize someone. So going back to that again, I don't want to sound too naively optimistic, but also understand that it's not frequent. Let me put it this way: I haven't heard from any of my colleagues or myself, or colleagues from American Immigration Law Association, any of the clients of known people being denaturalized, or there is no major conversation about this denaturalization, other than in the media, which unfortunately is spreading these intimidating news. That's also something. I don't want to go politically here, but we have liberal media who is supposed to be pro-immigrant, but basically what they're doing is they're doing what the Trump administration wants to do, right? So by spreading all these news, by taking the photographs of the ICE officers, arresting someone in the street, or dragging someone, an immigrant, or arresting immigrant families, the liberal media believes that they're trying, to fight against Trump policies, but they're actually promoting what they're doing, basically the job that Trump wants them to do. They basically spreading the word. They're they're promoting the fear in the eyes and minds of the immigrant communities, by a lot of times exaggerating what is really happening, but also showing and pointing this out. So yeah, denaturalization is not a big deal, but it is real, and it's possible, it's doable. So you should know that. What you should also know, as I've briefly alluded to, is that there is a lot of litigation going on about everything related to the new rules. The southern border, the 100,000 H-1B fees, limitations on the procedures, new rules how to file, even the filing fees increase. there is a lot of ongoing litigation, meaning a lot of lawsuits in courts where the immigrant rights organizations, or in some cases, some individuals, groups, and so on, they file class action against Trump administration, asking the court to block those new rules of Trump administration or Trump policies. And as I said, they issue a lot of executive orders or new rules, new memorandum in with the USCIS, Department of State, knowing that it will most likely be blocked. Unfortunately, the effect it has on immigrants and on immigration lawyers like us, we take the case, we're handling the case in the middle of the case, then suddenly a new rule comes up, right? So we have to now gear towards providing this type of evidence, or in some cases, they even issue forms, a new form that now we have to complete, right? And new information we have to provide together with adjustment of status. And then as we're about to complete everything within next week, a new rule comes up. Well, the court decision comes up that this new rule is now blocked. And then it gets appealed. The Trump administration appeals, and a sympathetic appeals court lifts the temporary injunction, although the main decision is still pending. And then now we have, so we call it roller coaster. So those things are happening. But in terms of citizenship rules, citizenship requirements, citizenship eligibility, I'm sure there will be some litigation as well related to this. At least it was during his first administration. So during Trump's first administration, they tried to do the same thing, or actually more than that. I think they increased the test questions even by more than what they did now. The filing fees were significantly increased, and all of this was controversial, and the courts, the federal courts, struck down, and they got blocked. It was at the end of Trump's first term. So there may be a lot of those things as well. Now, when I tell you about filing by October 20th, you never know. Maybe on October 20th, this is all going to change back to normal again. You don't know. But in any case, I wouldn't take a risk. If you're eligible for citizenship, or if you know someone who's eligible for citizenship, if you're not sure if you're eligible for citizenship, get in touch with us, get in touch with a qualified, experienced immigration lawyer, so that they can evaluate your case. We can evaluate your case. We've been doing it for 19 years. I am a licensed immigration attorney. I'm a U.S. Juris Doctor. I'm a member of Immigration Lawyers Association. So I will be happy to review. So contact us, contact other lawyers. Now, I want to talk about some other, topics, loud topics that everybody talks about, related somewhat to citizenship. So as to the path to citizenship, a lot of media and so on, because it sounds sexy, it sounds interesting, they're talking about Trump's gold card, right? So you've seen with Trump's face, the gold card, 5 million investment path to permanent residency, which is replacing EB-5. The first news, I'm sorry to burst the bubble of the excitement of this, that many have, is that there is no gold card yet. Trump wants to believe there is, and he has actual picture of it, but it's not enacted. So it's visible, but it's not enacted. That's number one. And I don't think it will be. It's just another thing that he says that's never going to happen, like resolving, Russia's war with Ukraine within one day, but that's not going to happen. So the gold card also cannot happen it cannot be enacted because Trump just doesn't, the executive branch, the president doesn't have power to do so. That's basically creating a new way to immigrate into the United States, right? So you may have heard, some of you may ask, well, how about the startup parole that Biden administration created, or deferred action for childhood arrivals for dreamers, DACA, that Obama administration created? But that's different. The problem with those is that they don't lead to citizenship, right? So that's not a pathway. That's not a new method of immigration. DACA is deferred action. So what Obama administration did, they decided that these children who were brought here when they were, these U.S. residents who have been brought here when they were children, under the age of, I believe it's 16 or 11, and they they grew up in the United States. All of they have seen is the United States. They don't have any path to U.S. citizenship. But what we will do is we will defer the action. Which action? Defer their deportation. We will let them stay here for the time being, and they'll have to renew it, and we'll give them work permits. So that's what they did. That was DACA, deferred action for childhood arrivals. That's under Obama administration. Now, during Biden administration, realizing that there was not enough opportunities for foreign entrepreneurs to start up businesses here, even though they may not have $1 million investment for EB-5, which is an existing path to permanent residence and citizenship. Creating 10 jobs and investing $1 million. Well, that's $1,050,000. So realizing that didn't exist for everyone, and the amount of investment may be less than that, the Biden administration came up with a startup parole. Now, parole also doesn't lead you to permanent residency. It's not even a non-immigrant status in the US, in a sense like E2 investor visa, for example, is, right? But not every country has the E2 investor treaty with the E2 visa treaty with the United States. It's treaty-based type of visa. So that's why they created this entrepreneur parole. Now, that's parole. That's just basically allowing them to temporarily be here, do the work. Humanitarian parole has always existed for someone for humanitarian reasons, medical reasons, to come to the US temporarily, even though they may not be eligible for a visa and so on. So those already existed. Those are temporary, basically deferrals of the actions against those individuals. Those are not new pathways. Gold card presumes a new pathway to permanent residence and citizenship. And no president has that power. It's just very straightforward. They don't have that power. It has to be decided by the Congress. The US Congress has to vote, and that would be part of the immigration reform. I don't anticipate the possibility that the Congress is going to vote on a gold card, but they're not going to touch the issue of dreamers, or they're not going to touch the issue of, other immigration pathways, which are significantly outdated. Some of the immigration laws are from 1950s, 1970s, are very outdated in terms of the technicalities, that the requirements and so on. So without touching any of those, there is no Congress that would basically just decide, oh, we're going to do this Trump's gold card because we like him. That's not the case. So with that being said, gold card, yeah, it sounds interesting, it sounds exciting, and it sounds newsworthy, and that's what feeds this administration, but it doesn't exist, and I doubt that it will ever exist. The possible increases, so the future changes to citizenship eligibilities, we're talking about, again, possible increases in continuous residence requirements or physical presence requirements. But again, those are the requirements, that the fundamental eligibility requirements, just like the gold card or new pathway. The Trump administration, the president doesn't simply have power to change the fundamental requirements. The interpretation of the laws, the applicability of the laws, how to interpret the Board of Immigration Appeals, the USCIS memoranda, the executive orders, they can try to skew those to make it harder, but a lot of that is going to be also, again, fixed and corrected and changed by the federal courts. But unfortunately, as we are going through this roller coaster of changes, for someone from outside, I'm not pointing at me because I'm not, I'm inside, I am within that roller coaster. But for some of you who may be observing it from the side, you may be like looking at it, oh, this court did this, but you have to understand that all of these changes, they affect lives of millions of individuals that live among us. So for them, this roller coaster unfortunately means that today you may not be eligible for permanent residence in the US. Tomorrow you may be ordered to be removed from the US. But if you had your case heard the day after tomorrow, maybe you will be eligible. Your family could stay and live here in the United States. Your children could grow in the United States. So for them, these roller coasters are not fun. Neither they're fun for us, but for us, it's more work, requiring more time, more efforts. But for those immigrants and immigrant communities, it's really devastating. It's life changing. I mean, somebody who may have been eligible for protection in the United States because of their fear based on their gender or gender violence. They could have qualified for protection in the United States 2 months ago, but they don't qualify anymore because Attorney General Bondi interpreted in a different way the case law. They interpreted the case law in different. So unless the federal court or either district court, circuit court, or the Supreme Court addresses this, we're going to have those roller coasters affecting human lives. So next, there will be potentially fee increases for naturalization cases. So the fees may go up. Currently, it's $710. It can be filed online. But the fees may change in the future. And I'm sure if they do implement those changes they're promising about vetting, neighborhood investigations, and so on, they do have to increase the fees because they'll need a lot more resources, a lot more officers. And I don't see the Congress allocating more budget. As you all know, the government is shut down. So I don't think the Congress is going to allocate more budget to do these vetting and investigations. Without significantly increasing the fees. But then if they increase significantly the fees, then it may be too controversial or too, I forgot the word, I'm sorry, and again, struck down by the courts. So there is always this balancing test. But the key advice for you applicants: file early for your citizenship if you're eligible, especially before the new rules get enacted on October 20th. Maintain consistency across all your prior immigration filings. Review all of your previous cases filed. Now, do that very thoroughly, especially if you have filed for asylum in the past, if you filed for even any kind of case, whether it's marriage-based case, even your visa application at the State Department, the consulate, when you first entered the United States, will be reviewed at the time of citizenship. Now, yes, there are some officers who, are not going to do the diligent job, but generally they're supposed to thoroughly review. Collect supporting documentation early. Make sure you get all the court records. If you have traffic tickets, whether you should get those certified disposition records. I'd say currently in this chaos, it's always a good idea to be on the safe side and collect as much of certified records, disposition, and so on as much as you can. And most importantly, I'm going to say this: seek legal advice and help. And there is nothing requiring you to have a lawyer, just like there is nothing requiring you to hire a doctor for a medical operation. There's literally nothing requires you to do so. You can try to do it on your own, but it's the good idea, probably not. So in this current circumstances, in this current world, do you want to file for citizenship by yourself? I wouldn't do it. So you at least want to consult, find out how difficult is your case, what kind of issues you may have. Talk to a lawyer, see if you feel comfortable with, look at their background, look at their reviews, look at the information about their past cases, and decide whether you want to work with that lawyer. But my strong advice is that work with a qualified, experienced immigration attorney to handle your case. And if you want an easy way to find one, we are here to help. So there's contact information there. So I will now try to answer as much of questions as I can. I know we started late because of the technical difficulty, but again, I apologize for everyone who wasn't able to join live because now the link has changed. I don't know how dumb it is for YouTube. I mean, as soon as you have technical difficulty, the link disappears. Basically, you have to recreate the whole thing. So, we've covered what's changing now, what is changing immediately. We spoke about, the upcoming potential changes. We spoke about the court cases, demystified some of the things like neighborhood investigations, de-naturalization, taking away somebody's citizenship, and gold card. So let me go through and see. I have see a lot of questions on the chat section. Thank you, everyone. So, how many total affidavits should be provided? There is no specific number. I always recommend to, as I said, get different types rather than number. But I'd say 3, 4 would be sufficient. Depends again on the specific case circumstances. So when you file, the question is how many affidavits for good moral character at the time when you file for citizenship do you need? And it's a good idea to provide, I would say 3, 4, not more, unless you have special circumstance such as negative history, criminal history, and so on. And then again, even there, it wouldn't be the number, but the quality of those affidavits. But thank you for your question. Um, Services court for marriage green card application and interview for marriage green card. Thank you for your question. But I cannot give you a quote on the services. Every case has specific circumstances. I'll tell you a ballpark for a marriage-based green card application and interview. I'd say it runs anywhere in the ballpark between 6,000 to 10,000, depending on the complexity of the case, and so on. But again, don't hold it against me. I'm just trying to help instead of just saying, "Oh, I cannot give you a quote." But you can contact us. There is all of the contact information below, and we do offer free initial consultation to discuss specifically that the cost. So if you're consulting with me, I'll ask you the questions I have to the extent that I need to know to be able to give you a quote, and I'll tell you what we can do. It's usually up to 15 minutes, and I'll answer as much questions as you can within those 15 minutes. So contact us, and I'll be able to give you exact quote for that. Next question is, if I apply for citizenship, do my children also need to take the civics test? No. So your children, they don't actually need to apply in many circumstances for citizenship because they may qualify for citizenship by virtue of you becoming a citizen. So if your child is under 18 and has been living with you, then they would normally qualify for, and they're permanent residents. Obviously, if you're applying for citizenship, you've been a permanent resident. If your child lives with you, they're most likely permanent residents as well, the green card holders, and they would become US citizens by operation of law. How long are green card renewals taking? The green card renewal depends on what. Is it green card renewal, just a 10-year green card being renewed? I believe that's around 1 year, 12 to 18 months. But then if you are renewing your green card, removing conditions because you got your permanent residency based on marriage with US citizen, that can take significantly more. In many cases, that takes about 3, 4 years. But your green card gets extended. In both cases, your green card gets extended. Well, in the case of removal of conditions, gets extended by virtue of filing. When your 10-year green card expires, you don't lose your permanent residency. Many people don't know this. So when your green card expires, even if your green card expired many years ago, you don't lose your permanent residency. You're still a permanent resident. You just lose the document, which you need to renew so that it shows that it's still valid. Similarly, by analogy, for example, if your passport expires, you don't lose your citizenship of the country which passport you're holding. You simply don't have the document valid enough to demonstrate that you're still citizen. But if somebody needs to look, like if the US government wants to know, they'll find out that you're a US citizen. So if you're abroad, just hypothetically, let's say you're abroad, you're overseas, and your green card expired, can you return to the United States? Yes, you can, because you're still a green card holder, you're still a permanent resident, and the US Customs and Border Patrol agent will be able to find out that you're still a permanent resident, and you will be allowed to enter the United States, even with expired green card. Okay. Next question. I have a quick question. I applied I-485 from also beside that I filed I-130 from the travel documents. My question is nowadays, how long wait time to receive travel document? So travel document, meaning advance parole, which allows you to travel outside of the US during the pendency of your green card application, currently takes about 8 months from the time of filing, sometimes even longer than that. And in many cases nowadays, what we see is your green card gets approved even before you advance parole. Now, if you have emergency reason, if there is an urgent humanitarian reason why you need to travel abroad, why you need to leave the US while you're waiting for adjustment of status to permanent residency, then you can ask, number one, you can ask the USCIS to expedite what you've already filed. Number two, you can file an emergency advance parole request with your local USCIS office. So local field office, right? So here in Virginia, for example, we have Fairfax office. So you would file your emergency advance parole and you would schedule an in-person appointment to get it. You can technically get it within 2-3 weeks, but you do need emergency, urgent humanitarian reasons to be able to do that. All right, thank you for the question. Next question is, asylum case online status changed 1 month after the interview from decision pending to new card being produced. It turned out my asylum case was approved. Oh, okay, you asked me last time. Yes, thank you. Okay, well, very good. Congratulations. Produced in New York, work permit with carrying AO5, USCIS sent the card automatically. Great, congratulations. I remember from last conversation you were saying that your case status changed, but you didn't know what it was. Can I apply for the refugee travel document myself, or do I need a lawyer to do that? Thank you. Okay, I always try to answer this question in the same way, is that you're not required to hire anyone to do anything for you. You can always learn to do things. You can always do things. You can build a house yourself, but it's risky, or it may not be risky. I mean, in the case of refugee travel document, you may file it, wait for it for months, and then it may be denied for technical reasons. Now you lost all this time. That's the risk. I mean, nobody's gonna, try to take away your permanent residency or asylum because you made a mistaken travel document. Well, unless they think you misrepresented information. So there are twists and turns. Bottom line is, read the instructions, review the form, see if you feel comfortable spending your time on doing this, and if you feel comfortable, with all the uncertainty that you may have doing it, then you decide whether you want to do it or not. And in the end, still don't do it yourself. No, I'm kidding. I mean, no, it's, think about it and make a decision. Nobody can tell you have to hire a mechanic to fix your car, or, an engineer to build a house, because nobody knows what you're capable of or what you know. Next question is litigation on GMC. What's the question? Litigation of good moral character? Yeah, there is litigation on good moral character. I mean, I assume there are cases related to lack of good moral character if somebody is denied citizenship based on that. I'm sorry, I didn't understand the question. If you want to repost it, that would be helpful. Next question is, am I eligible to apply for citizenship if I haven't filed taxes due unemployment and don't owe taxes? Okay, very good question. And I did not talk about taxes, the effect of failing to file taxes for the citizenship purposes. So for citizenship, you must have filed all your taxes in the past, or you must demonstrate a reason why you have not. The important part is they want to know, well, there is a question in the form. Have you ever failed to file taxes because you considered yourself as a non-resident, right? So some permanent residents may have received, let's say, a travel permit, what do you call, re-entry permit, and be absent from the United States for 2 years because they work abroad, and they may believe that they don't have to file taxes. And then down the road, when they apply for citizenship, there is this question: have you failed to file a tax return because you considered yourself as a non-resident? And if you mark yes, then that might be a big issue for citizenship. Unless there are some exceptions and so on, but generally that would be a ban for citizenship, or it may be even used to claim that you abandoned your permanent residency. Basically, being a permanent resident, you didn't consider yourself permanent resident. But if you did not file taxes, generally, what I would do, because that question in the form is very specific, it says, have you ever failed to pay taxes because you did not consider yourself a US permanent resident? Somewhere around that. I don't remember the exact wording. But because of that wording, generally what I recommend doing is marking it no, but then in the addendum still disclosing that I did not file taxes, and here's why. And if you can get a qualified letter from CPA, a letter from qualified CPA, certified public accountant or tax accountant, who would also confirm that, yes, Marisol did not have to file taxes because she was unemployed or where she doesn't owe taxes, that would be very helpful. Now, if you were unemployed, but if you were getting some kind of other kind of benefits, maybe unemployment benefits, maybe that was taxable. The best idea is you don't want to basically be the one making decision that you didn't have to file taxes, right? So because technically you may owe taxes because you didn't know that you had to file taxes or not. So technically for you not to file taxes and claim to the USCIS that you didn't have to file taxes, you need to have an expert in this case, which is a tax accountant, which is a certified public accountant, who needs to write a confirmation that Marisol was unemployed. She may have gotten some kind of benefit, but that doesn't even qualify. I'm just guessing. I'm not a tax advisor. I don't know. I consult myself with an accountant, tax accountant, with a CPA whenever I have these questions. So you need to consult with them. First, confirm that you didn't have to file taxes. And if so, then get a letter confirming, certified basically, so by that CPA certifying that you didn't have to. And that you don't owe any taxes. Now, if you owe any taxes, that's not end of everything. You can owe taxes to IRS, and you can still qualify for citizenship. But what you need is to confirm that you're paying. You have some kind of payment arrangement with IRS. So you need a signed letter from IRS. Not a difficult thing. It's a signed letter, and it sounds very vague, but usually, if you have some kind of payment agreement, there is a signed letter in the file. You can probably pull it online from your IRS account. So you need that, and you need your current statement confirming that you're current on your payments, that you did not miss any of those payments, that you have an agreement for paying your old taxes and you're current on payments. So don't be alarmed if you do have taxes owed. That's not end of everything, but if the other option is to pay. It's not a big amount. You can just pay before citizenship and provide that information with your citizenship filing that you're current on your taxes because you paid, right? Evidence of the payment. But the other trick, what you can do is, if you have tax, you're thinking, should I file tax return, or I missed some taxes in the past? At the time when you're preparing for citizenship, you can always have your accountant file taxes for the prior years, right? There's nothing wrong, even filing with zero tax return, right? So a lot of times, USCIS officers are trained that there has to be a tax return, and then you provide a letter from CPA saying you didn't have to file a tax return. That kind of distracts the officer from what they routinely see. What I'm trying to say is that your goal is to get your case approved as soon as possible. And if the officer reviewing your case is used to seeing tax returns, right? For example, in a marriage-based case, affidavit of support, or even with the citizenship cases. By the way, I forgot to mention that as well. It's advisable now, after October 20th, to also attach copies of your tax returns as affirmative proof of good moral character. But anyway, we'll make a post. We'll list all of those things. But I, was trying to give you generally everything I could. But so if the officer is used to seeing a tax return, give them a tax return, right? So it's not going to cost much for your CPA to file a $0 tax return for the 2 years, 3 years, or even 5 years going backwards. But give them the tax return. In the end, you're going to have less likely you're going to have any
additional requests for evidence, delaying your case, and issues, and so on. So that's how we, for example, in our law firm, we approach. Of course, if it's a burdensome process, we don't want you to do it if we can demonstrate it to the officer. But a lot of times we have these type of situations, for example, in investment-based visas, right? So in some petitions for permanent residency, some of the officers they are used to seeing copy of a bank check, right? So that's why we tell the clients, in today's world you can pay someone via Zelle, Venmo, transfer, and so on. But if you can use checkbook, because a lot of officers are used to, or consular officers, they're looking into, or if you're applying for investor visa, because the regulation and the manual they're seeing, right? That's how outdated our immigration laws are, or the manuals and so on, because the manual is saying, look, for canceled checks, right? The checks, clear checks from banks showing that somebody paid for the equipment they bought. So we advise the client, try to use the checks so it's easier proof, easier to document. And that's what the officer is used to seeing, rather than paying through Venmo and then explaining to the officer who may not know what Venmo is. Why put that extra task on yourself? Okay. Next question. If I get rejected from USCIS and still have visa, what is happening? I don't understand the question. And rejected from what? What type of visa you have? What you applied for before? Also, if I apply today for asylum to USCIS, what is the fastest time that I could get appointment? 2 months, 4 months? It's unpredictable. So we had a live stream about asylum filing. So what I want you to do is go back to our videos. That's another reason why you should subscribe to our channel. Go to our prior videos and look for the information about the asylum. But I'll tell you briefly here that the time for the asylum interviews is unpredictable. It's chaotic. It may be within 2 months, 4 months. It may be 6 months. It may be 6 years. So there is no clear timeline. Now, if you filed for asylum and you did not provide complete information, or it's beyond 1 year deadline, they'll most likely schedule it quick to kind of get rid of your case as soon as possible. All right. Price range for USCIS asylum. If I work with you, again, there is that we cannot give quotes for specific cases. Every case is different. Every case, there is a lot. There is, your circumstances. What is the basis? Which location? What kind of case is it? There's a lot to determine. But I'll tell you roughly, again, I want to help and try to not seem like I'm not answering questions directly. Roughly somewhere between 8,000 to, 12, 15,000 in the complicated cases. But in asylum case is such a thing that there is no limit, right? So sky's the limit. I mean, you can do you can engage a bunch of experts and so on in your case. The cost can rise, but generally anywhere between 8 to 12,000 is the cost of the asylum case, preparing, filing, work permit, and so on. But the best idea is you have our contact information. So contact us, you'll get a link. You can schedule free initial consultation where it's specifically designed for you to get an exact quote for your case, where we will ask you the questions we have. It's not for consultation, it's not for general legal advice, but it's for specifically knowing information about your case, telling you what we can do and how much that costs. All right. Next question. I applied for green card renewal. I've not heard back from them, but I am eligible for naturalization already. Can I apply or need to wait for renewal? Good question. Very often happens. No, you don't need to wait, and you should not wait. This specific situation is if you applied for green card renewal based on removal of conditions. So if it was a 2-year green card because you married with a US citizen, now you filed for the 10-year green card to remove the conditions. That process takes roughly about 3 to 4 years if you don't file for citizenship. If you file for citizenship, it pushes it forward, and the USCIS will review both citizenship and your green card renewal at the same time. But the short answer is no. File for citizenship as soon as possible and do it before October 20th if you're eligible. Now, I don't want anyone to get burned by filing it too early. You can file for citizenship generally 5 years from the time of your permanent residency minus 90 days. So you qualify for citizenship after 5 years of your permanent residency and deduct 90 days, you can apply. That means you can file it 90 days before your eligibility date. Now, if you're married with a US citizen and have been married for 3 years with a US citizen and you were a permanent resident during those 3 years, then you can also file for citizenship. And again, you can file 90 days before that 3-year anniversary of your permanent residency and living and marrying, being married and living together with US citizen. So there are some challenges to these formulas. Then there is continuous presence, physical presence, and so on. So strongly advise, again, to consult with immigration lawyer to make those calculations to make sure that you don't file it too early or that you qualify, you don't miss, or you don't file too late. Sometimes people think that they don't qualify yet, they cannot file, but they can file. So, but the short answer is yes. In your case, if you filed for green card renewal, removal of conditions, you can file for citizenship even though you didn't get your new green card. But if you regular 10-year green card is expiring, you don't even have to file for renewal of it. You can just file for citizenship. You're not required to file for the renewal of your permanent residency. Okay, the clarification. I would like to ask direct question. My visa expires on May. Want to apply such that even if USCIS doesn't approve it, I would have a chance for court. What would you recommend? All right, that's that question also was specifically addressed during the last video recording, but I'll repeat here, it's very important. No, you don't have to wait for visa expiration. That's a false information you're getting, that you will not have a chance to have the court review it if you apply it during your visa status being valid. That's wrong. They're giving you wrong information. Do not rely on this. File for asylum if you qualify for it. If you have legitimate reasons, file for it as soon as possible. If you remain in status during your asylum interview, that's even better. You have much higher chances. You have better chances. And if it's denied, not granted by the USCIS, you don't lose the chance to have it reviewed by the court. You actually keep that chance in your back pocket, and you can always use that chance in the future. But the benefit you're going to have is multifold. If you file your asylum application while you're in status and you go to the interview and you have valid non-immigrant status, the officer is going to be more, sympathetic, or maybe believe more that you're not just simply trying to find a way to stay here and work, but you already have a valid status, but you're asking for asylum. That's number one. Number two, if the officer doesn't grant you asylum, you will get a chance to get their written opinion about why they don't want to give you asylum, and you will have a chance to even respond to the officer, to basically communicate with the officer back, saying, oh, this is why. So you will basically, it's called notice of intent to deny. So to explain it a different way, if you're in invalid status and the USCIS doesn't want to grant you asylum, they have to send you a notice of intent to deny, explaining the reasons why they don't want to give you asylum, and giving you a chance to respond to those reasons. And technically, they would have to review your response and make a decision afterwards. So that chance you don't have if you don't have a status. And finally, if you do get denied, you return back to your current status, and you still have possibilities of changing the status to something else. And the opportunity to have the immigration judge to hear your case, you keep that in your pocket, figuratively speaking. Anytime you lose status in the future, you can refile for asylum and have your case referred to court, and you will have that chance to have the immigration judge to review your case. All right. Next question. Also, if applied before October 20th, new rules will not be applied. Yes, correct. That's the entire point of filing before October 20th, is that the new rules, the new harder rules for citizenship eligibility will not apply you should file before October 20th. Do we need affiliates for good do we need affiliates? No, do you mean need affidavits, I guess what you mean. For marriage green card application. No, not for good moral character. For green card application, marriage-based green card, I wouldn't say that you need good moral character letters. I mean, unless you have some negative moral character evidence, such as claim of abuse, protective order against you, and so on. I wouldn't say you need that. Based on DV lettering, not asylum. Okay, good. I don't know. Yeah, based on diversity lottery. Okay, that. You're saying that qualifying for filing for October 20th citizenship, if you've had permanent residency based on diversity lottery, that's a green card lottery, and not asylum. That's good. So that same rule applies. Yeah, you still have to file it. Should file it before October 20th. I have student visa that expires on May. That if I get appointment before visa expiration date and USCIS doesn't approve it, I will never have chance for immigration court, so my case ends there. No, that's wrong. As I said, that's wrong information you got. It doesn't end there. I've explained it thoroughly. Z Parker says, I have an appointment next month for my naturalization interview. Should I study the 2025 test? No, you don't have to study 2025 test, and they cannot apply 2025 test to you, even to those who would be filing now until October 20th. So you have literally 10 days to file to avoid the 2025 test. That would be 2008 test applicable in your case. But again, to answer your question, no, you don't have to study the new test. All right. I think that's good so far. We spent about an hour and a half, but again, I started later because of technical glitches. I appreciate everyone joining. I appreciate everyone who liked this live stream. I appreciate everyone who shared. And again, I apologize to those who were not able to join because of the technical difficulties and the link having changed. So thank you, everyone. Please contact us. You have all the information below, all the contact information. We do offer different types of consultation, and we'll be happy to help everyone. Thank you, and have a good night. Bye-bye.